Please be advised that this recorded webinar has been edited from its original format, which may have included a product demo. To set up a live demo or to request more information, please complete the form to the right. Or if you are currently not on CSE Global, there is a link to the website in the description of this video. Thank you.
Hello, everyone, and welcome to today's webinar, First State Update, 2020 Case Law Developments and Updates to Delaware General Corporation Law. My name is Annie Triboletti, and I will be your moderator. Joining us today are guest speakers Roxanne Hauptman, Christopher Kelly, and Michael Maxwell of Potter, Anderson, and Caroon. And with that, let's welcome Roxanne, Chris, and Mike.
Thank you, Annie. Good morning, everyone, and thank you for attending this First State Update webinar on Delaware corporate law developments. My name is Chris Kelly, and I'm a partner in the corporate group at Potter, Anderson, and Caroon, practicing primarily corporate litigation in the Delaware Court of Chancery. And as Annie mentioned, I'm joined by my partners today, Roxanne Hauptman and Mike Maxwell. Roxanne is a partner in the firm's corporate group as well. Her practice primarily involves counseling Delaware corporations on transactions and governance issues. And Mike is a partner in the business group at Potter Anderson, and he primarily advises clients on Delaware corporate and alternative entity law issues in transactions involving Delaware entities. In addition, Mike and I are contributors on the CSE publication, Delaware Laws Governing Business Entities. We will begin the webinar today with an overview of a few of the significant court decisions over the past year, and then we'll turn to the key amendments to the Delaware General Corporation Law. We'll then have a discussion and Q&A section. Please feel free to submit questions at any time or near the end of the program. Our statements today are those of the speakers alone and not the views of our firm, any other firm lawyers, or any firm client. With that intro out of the way, let's turn to the case law developments. The first case we'll discuss today is the case of In Re Dell Technologies, Inc. Class V stockholders litigation, a decision by the Court of Chancery in June of this year. The case involved a challenge by former holders of Dell Class V stock to the company's redemption of the stock. According to the plaintiff's complaint, the Class V stock was tracking stock based on the company's 82% ownership stake in VMware. The Class V stock, however, did not track the value of VMware, but rather traded at a 30% discount, allegedly because the Class V shares were subject to the company's right to forcibly convert the shares pursuant to a pricing formula in particular circumstances. The Dell board began exploring ways to consolidate the company's ownership of VMware and ultimately charged an existing board committee with negotiating redemption of the Class V stock. According to the complaint, the board, attempting to satisfy the MFW standard, conditioned any redemption or similar transaction on both committee approval and approval by a majority of Class V shareholders. The company, however, reserved the right to bypass the MFW process by engaging in a forced conversion. After identifying a potential conflict as to one of the existing committee members, the board then formed a special committee that did not include that member. The board again conditioned any redemption or similar transaction on compliance with MFW, but again reserved the right to bypass MFW by engaging in forced conversion. According to the complaint, during negotiations, the company allegedly repeatedly informed the committee that if they did not agree to a negotiated redemption, then the company would proceed unilaterally with a forced conversion. The committee ultimately agreed at the conclusion of the negotiations to a negotiated redemption which valued the Class V shares at approximately $21.7 billion in total. Large stockholders objected to the deal, and it appeared that the Class V stockholders may not approve it. Rather than negotiating further with the committee, the company then negotiated directly with 6 large Class V stockholders. At the same time, the company allegedly took public steps to prepare for a forced conversion. Following negotiations, the company and the large stockholder group ultimately reached an agreement on a new deal valuing the Class V shares at approximately $24 billion in total. The special committee had not been involved in negotiations between the company and the large stockholders. When the company informed the committee of the terms of the stockholder negotiated redemption, the committee allegedly met for an hour and then approved it. Thereafter, the unaffiliated Class V stockholders approved the deal and it subsequently closed. Plaintiffs in the case were former Class V stockholders, and they brought suit against Dell's founder and the private equity firm that together controlled the company, as well as the members of the board, alleging that the defendants breached their fiduciary duties when negotiating and approving the stockholder negotiated redemption. On a defense motion to dismiss, the court largely denied the defense motions, primarily rejecting the defendant's pleading stage argument that MFW necessarily applied because the complaint alleged facts that made it reasonably conceivable that the defendants failed to comply with MFW's requirements, making entire fairness the operative standard of review. The court also rejected the special committee members' argument that the plaintiffs failed to plead a non-exculpated claim against them, but the court did dismiss on an interlocutory basis the director who had served on the original existing board committee, but who was quickly excluded from the special committee due to a potential conflict. Focusing on the court's MFW analysis, under the Supreme Court's MFW decision and its progeny, as you may know, if a corporate transaction with a controlling stockholder follows the MFW framework, then the transaction will receive the benefit of the business judgment rule. There are 6 necessary requirements for obtaining MFW cleansing. 1, the controller must condition the transaction on the approval of both the special committee and a majority of the minority stockholders. 2, the special committee must be independent. 3, the special committee must be empowered to freely select its own advisors and to say no definitively. The special committee must also meet its duty of care in negotiating a fair price. The vote of the minority must be informed, and there must not be coercion of the minority. The court found, based on the plaintiff's complaint, that there were well-pled allegations that at least 4 of those requirements conceivably were not satisfied. First, the court found that the plaintiffs had adequately alleged that the MFW conditions were not properly established at the outset because, according to the complaint, the company excluded a forced conversion from the scope of the MFW conditions. According to the court, the special committee was never fully empowered to say no because the company reserved the right to engage in a forced conversion and threatened both the special committee and the company stockholders with that alternative. Likewise, the court found that the plaintiffs had well pled that the company did not respect the MFW conditions because it bypassed the special committee by negotiating directly with the large stockholder group. The court explained that MFW's dual protections contemplate that the special committee will act as the bargaining agent for the minority stockholders, with the minority stockholders then rendering an up or down verdict on the committee's work. The court explained that those roles are complements, not substitutes. Second, the court found that there were well-pled allegations in the complaint that the special committee and the stockholders were allegedly subject to coercion by the company's alleged threats of the forced conversion. The court explained that by doing so, the company both undermined the special committee's ability to bargain effectively, as well as the ability of the stockholders to vote down the deal. Third, the court found that the plaintiffs had well pled that neither special committee member was independent from the company's founder and the private equity firm controllers based on the specific allegations of social connections, friendships, and business relationships in the case. Fourth, the court found that the plaintiffs had sufficiently alleged that the Class V stockholder vote was not informed, including based on the alleged failure to disclose the price of the special committee's final proposal, alleged disclosure deficiencies regarding the committee's advisors, and the committee's knowledge of a prior valuation at a much different value. So, having summarized the case, what are some of the key takeaways from it? Well, the primary takeaway, one of the primary takeaways is that the scope of the special committee's mandate is critical in invoking the safe harbor of MFW. As the court explained, the committee must be fully empowered to say no. Another key takeaway is that starting with a conflicted special committee is not necessarily fatal to application of the MFW safe harbor. However, continuing with the conflicted special committee will preclude MFW from applying. The court has in the past, as you may know, applied MFW where there was a prompt resignation of a conflicted committee member. A third key takeaway is that if hoping to invoke the MFW safe harbor, transaction planners should consider the operative standard for the independence of special committee members when evaluating who should serve on a special committee. Are the members sufficiently loyal to, beholden to, or otherwise influenced by an interested party in the transaction so as to potentially undermine the director's ability to judge the matter on its merits? The court will look to social ties, friendships, business dealings, etc., and will view allegations in a complaint holistically and not individually. An important point is that there has been a trend, an observable trend in the past 5 years or so of the Delaware courts looking with perhaps heightened scrutiny than in the past at such relationships when evaluating director independence. Another key takeaway from the case is that a controller can be found to have engaged in coercion by threatening to exercise a right it possesses. Thus, just because the forced conversion right was in the company's charter, that simply means that it's legally possible. As the court explained, it doesn't necessarily make it equitable. Delaware has what's called a twice-tested paradigm. Fiduciary conduct faces two tests. The first test is legal. The second test is equitable. As the Supreme Court has held, inequitable action does not become permissible simply because it is legally possible. Those are just some of the key takeaways. I could talk about the Dell case at length, but given that we only have an hour or so, we'll move on to the next case, which is the mind-body case. That involved plaintiff stockholders' challenge to the sale of mind-body to a private equity firm. In the case, the plaintiffs alleged that the company's CEO and founder, the CFO, and the director appointed by the venture capital firm that held a large stake in the company tilted the sale process in the private equity firm buyer's favor due to alleged conflicts of interest in the form of the CEO's alleged need for liquidity, both the CEO's and CFO's alleged prospect of future employment, and the VC firm investors' alleged desire to exit its investment. According to the complaint, the company had made 2 strategic acquisitions in 2018 that the company had touted to stockholders and analysts would yield significant growth for the company in 2019. Despite the company's alleged bright financial prospects, the CEO was allegedly motivated to force a sale of the company due to his personal wealth being tied up in company stock and his alleged overextended personal finances. The complaint then alleged that the VC firm investor was motivated to force a sale because its investment was held in a fixed life fund. The firm had sought to exit its investment in 2018, and its board designee planned to step down from the board in 2019. And the VC firm could not easily sell its large block of stock without accepting a discount. According to the complaint, the CEO or founder reconnected to the private equity firm buyer through an investment banker, and he attended the private equity firm's portfolio company CEO summit, which allegedly had touted the enormous wealth generated for founder CEOs following the PE firm's take-private transactions. Thereafter, the PE firm made a direct expression of interest to acquire the company at a substantial premium to its trading price. The CEO, in response, allegedly informed some members of senior management about the expression of interest, but had allegedly instructed them not to discuss it with the board. The CEO and CFO then allegedly conducted an earnings call wherein they lowered the company's guidance, which allegedly was not consistent with management's actual expectations about the company's future performance. And that resulted allegedly in the stock price dropping significantly soon after. Around that time, the board formed a transaction committee chaired by the VC firm's board designee for the limited purpose of reviewing the potential engagement of a financial advisor to evaluate potential strategic alternatives. Two financial advisors then pitched the committee, and the committee allegedly went with the CEO's direction to retain the financial advisor that had reintroduced him to the private equity firm buyer and had already been in discussions with the CEO regarding a sale process. Thereafter, the board expanded the committee's mandate, which initiated a sale process. The CEO and the financial advisor allegedly then selected potential bidders to contact. Meanwhile, the CEO had allegedly been in touch with the private equity firm throughout this time and had provided diligence to the private equity firm. Other bidders, in contrast, allegedly received less information, and the CEO declined to include certain potential bidders in the process. After receiving an offer from the private equity firm at $35 a share, the committee directed its financial advisors to tell all potential bidders about the competitive nature of the process, the accelerated timeline, and the need for prompt indications of interest. The advisor then allegedly instructed two of the potential bidders to provide an indication of interest within the next 24 to 48 hours. And in response to the committee's acceleration of the process, all other potential bidders withdrew. After the board made a counteroffer of $40 a share, the private equity firm buyer countered at $36.50, which the board approved. The CEO and CFO were then allegedly on vacation during a highly compressed go shop that began on Christmas Eve, and the company allegedly delayed in entering into NDAs and providing diligence to certain prospective bidders. The company then allegedly failed to disclose its massive beat of in its fourth quarter results from the prior lowered earnings guidance it had given. With the CEO and the VC firm's irrevocable proxies in favor of the merger, which accounted for approximately 40% of the company's voting power, a majority of stockholders approved the transaction and thereafter closed. In response to the plaintiff stockholders' complaint challenging the merger, defendants had moved to dismiss, arguing that Corwin cleansing applied due to a fully informed stockholder vote approving the transaction. On the defense motions to dismiss, the court largely denied those motions. By way of background, as you may know, the Delaware Supreme Court's decision in the Corwin case and its progeny that followed hold that a irrebuttable presumption of the business judgment rule arises when a transaction is approved by a fully informed, uncoerced vote of the disinterested stockholders. In analyzing the defense motions to dismiss, the court first found that the plaintiffs had adequately pled a paradigmatic claim under Revlon due to their allegations of, quote, a supine board under the sway of an overweening CEO bent on a certain direction who tilted the sale process for reasons inimical to the stockholders' desire for the best price. The court explained that the plaintiffs had sufficiently alleged that the founder CEO breached his fiduciary duties in that he allegedly was conflicted because he had an interest in near-term liquidity and an expectation that he would receive post-merger employment accompanied by significant equity-based incentives from the PE firm buyer post-merger, that he allegedly tilted the sale process by strategically driving down the company's stock price and providing the private equity firm buyer with informational and timing advantages during due diligence and the go-shop periods, and allegedly withheld material information from the board, and that the board failed to adequately oversee the founder CEO. The court next found that the stockholder vote was not fully informed, and thus the Corwin defense did not apply. Based on the plaintiff's allegations, the court found disclosure deficiencies in the form of the allegations regarding the CEO's conflicts of interest and his alleged efforts to tilt the sale process in the PE firm buyer's favor, including regarding post-closing employment, the initial expression of interest, and the PE firm's timing and information advantages during the sale process. The court also found disclosure deficiencies in the form of the allegations made by the plaintiffs regarding the actual Q4 results versus the previous lowered guidance, and the proxy's description of the merger price as a premium to the trading price. The court explained that plaintiffs had made well-pleaded allegations that the CEO allegedly drove down the stock price by lowering Q4 guidance, rendering it reasonably conceivable that the Q4 actuals would correct the misleading impression created by the deflated stock price and the merger price premium that was based on it. The court next found that the plaintiffs had well pled a fiduciary claim against the CFO, finding it reasonably conceivable based on the allegations in the complaint that the CFO acted with gross negligence during the sale process due to his putative reckless indifference to the CEO's efforts to tilt the process. Lastly, the court dismissed the VC board designee on an interlocutory basis, finding that the plaintiff's allegations of a liquidity-driven conflict to be unpersuasive. So what are some of the takeaways from the mind-body case? Well, first, a board or a transaction committee should play an active and direct role in the sale process. As the Delaware Supreme Court has stated, a board cannot avoid its active and direct duty of oversight in a matter as significant as the sale of corporate control. The Delaware courts have also explained relying entirely on advisors or management to conduct the sale process can potentially, in certain cases, taint the design and execution of the transaction. Part of the board's duties or a transaction committee's duties is being proactive about identifying and responding to actual or potential conflicts of interest involving the directors, officers, or advisors. Second, before appointing a director designee of a large stockholder to a transaction committee, a board should evaluate whether the stockholder may potentially have interests that could conflict with those of the company's other stockholders. A third takeaway is that if senior management is involved in the sale process, a board or transaction committee should consider whether there may be any potential conflicts of interest, including with respect to potential post-merger employment. A final takeaway is that officers involved in the sale process, and in general, should understand that they owe fiduciary duties to the company and the stockholders. Also, unlike directors, corporate officers do not have the benefit of a Section 102B7 exculpatory charter provision. As a result, a breach of the duty of care, gross negligence that is, could be enough to result in liability. So with that, I'll turn it over to Mike to discuss 2 other cases.
Great. Thanks, Chris. So I'm next going to cover a decision from the Delaware Court of Chancery from earlier this year in which the court addressed an attempted board coup instigated by a founder. So in this case, Palisades Growth Capital v. Backer, a founder, Alex Backer, who had been removed as a CEO of a company called QLess, took advantage of 2 board vacancies, one of which could have been filled but for inaccurate legal advice to the venture investors. And he took advantage of these board vacancies to pass resolutions firing the new CEO and reappointing himself, the founder, as CEO. It also stacked the board with 3 aligned directors and increased the quorum to 3 directors. The resolutions were passed by a 2-1 vote, with the founder and his father and fellow director passing the resolutions over the objection of the 3rd director, which was elected by one of the venture investors. The effect of the resolution, if valid, would have been to lock in the founder's control over the corporation. So the attempted coup took place at QLess, which is an early-stage startup. It develops and licenses a queue management system for retail businesses. Alex Backer was the founder of QLess and owned a majority of the common stock. He was also the CEO at one time. Backer's father, Ricardo Backer, is also a director. Palisades Growth Capital was a principal investor and owned a majority of the Series A preferred stock. And Altos Hybrid 2 was another principal investor and owned a majority of the Series A1 preferred stock. So the governance scheme at QLess on the whole seemed fairly common to what you might see in a venture-backed startup company. The scheme sought to allocate control between the founder and the venture investors through separately elected directors pursuant to the Certificate of Incorporation and Charter. So the board size, so as you may know, under Section 141B of the DGCL, unless a Certificate of Incorporation fixes the number of directors, the number of directors is set by or in a manner provided in the bylaws. Now, QLess's certificate did not fix the number of directors, and its bylaws permitted the number of directors to be fixed by resolution of the board of directors or by stockholders at the annual meeting of the stockholder. Consistent with the bylaws, a board resolution fixed the number of directors at 5. With respect to the director seats, the Certificate of Incorporation established separately elected director seats. 2 seats were to be filled by the holders of the common stock, voting as a separate class. And these are referred to as the common stock directors. 1 director was to be elected by the holders of the Series A preferred stock, voting as a separate class. And these are referred to as Series A director. And 1 director elected by the holders of the Series A1 preferred stock, voting as a separate class, which was the Series A1 director. And finally, 1 director was to be elected by all stockholders, common and preferred, voting as a single class, and this was an independent director. Now, the Certificate of Incorporation and the voting agreement suggested that Backer and the venture investors contemplated a situation in which Backer would be removed as CEO and the new CEO would be added to the board. Rather than immediately remove one of the 2 common directors to make room for the new CEO on the board, the documents contemplated an 18-month transition period. Therefore, for 18 months following Backer's removal from the board size would be increased to 6, thereby making room for the new CEO. And then at the end of the 18-month period, the common stockholders, voting as a separate class, would only elect 1 director, and the board would shrink back to 5 members. Now, Palisades, Altos, Backer, and certain other stockholders also were party to a voting agreement. And in that voting agreement, they agreed to take certain steps that would ensure that the individuals selected by Backer, Palisades, and Altos would fill the seats on the board. So to that end, they agreed to elect a Palisades designee to serve as the Series A director, and Altos designee to serve as the Series A1 director, to elect 2 people designated by the holders of a majority of the common stock to serve as the common stock directors, and to elect 1 mutually agreeable person who satisfied certain independence criteria to serve as the independent director. Now, in addition, and consistent with the contemplated potential removal of Backer as CEO and the ensuing transition period, in the voting agreement, they also agreed to maintain the board size at 5, except for the 18 months following any termination of Backer, when the board should be set at 6. The size would be set at 6. and following any termination of Backer, to elect the company's CEO to serve as the CEO director. So Backer was removed as CEO in June of 2019. Now, while the reasons for his removal may not be important, it could be useful to understand that the removal was contentious and was not undertaken until after a special committee investigated allegations of misconduct against Backer and recommended his removal. So when he was removed, the board had a full complement of 5 directors. The founder, Alex Backer, and his father, Ricardo Backer, held the 2 common director seats. Palisades designee Anderson held the Series A director seat, and Altos designee Hodong Nam held the Series A1 director seat, and Ivan Markman held an independent director seat. The company did not hire a new CEO until September 2019, when it hired Kevin Grauman with the apparent approval of Backer. Once hired, under the terms of the voting agreement, Grauman needed to be added to the board. Now, as a technical matter, before he could be added to the board would need to be expanded to 6 directors, and that expansion, per the company's bylaws, can only be accomplished by board resolution or action by stockholders at an annual meeting. It appears that no formal action was ever taken to add Grauman to the board, no vote, no written consent, and no resolution or stockholder action expanding the board to 6. So around the time Grauman is hired as the new CEO, the A1 director resigns, so the A1 director seat is vacant. After discussing the vacancy with Palisades, Altos determined that it wants to fill the seat with a gentleman named Paul Daddario. Now, Altos counsel sends an email to the company's counsel to that effect on October 28th. So in the email, Altos counsel states that Altos would like to fill the vacancy left by Nam's resignation as soon as possible, and requests that the company's counsel draft and circulate the necessary stockholder consent to elect Daddario to the QLS board as the Altos designee. Now, the company's counsel responded and advised, presumably in good faith, that filling the vacancy required passage of a board resolution at the duly called meeting. And that advice was inaccurate. It's incorrect, because the certificate of incorporation allowed Altos, as the holder of a majority of the Series A1 preferred stock, to elect its designee by vote or written consent. So as a result, Altos could have called a meeting of the A1 preferred stockholders to elect Daddario, or alternatively, and probably more efficiently, Altos, as the holders of a majority of the Series A1 preferred stock, could have executed a written consent electing Daddario. But Altos did not do so. Instead, in reliance on the advice of the company's counsel, it took no further action to elect Daddario, assuming instead that it would be addressed at a board meeting. So on October 27th, Backer requested that the board convene for a meeting on November 15th. In the email traffic regarding the scheduling of the meeting, Backer indicated that he assumed and requested that the board include the new CEO, Grauman. At that point, however, there had still been no action to increase the board to 6 or to elect Grauman to the board. On November 11th, at Backer's request, Grauman circulated proposed resolutions for the board meeting that would, if adopted, appoint Daddario to the board and confirm Grauman as the CEO director, and no one objected to the resolutions. The day before the scheduled board meeting, Markman, the independent director, resigned. In the opinion, the court suggests that Markman resigned after he spoke to Backer, and Backer informed him that he was going to attempt to reinstate himself as CEO. In language that suggests a certain degree of possibly director fatigue, Markman told the court that he had resigned because he decided he just didn't have time for it anymore. So at the board meeting, after Markman resigned, Backer saw the opening. If the board consisted of just 3 directors, 2 common directors, which would be Backer and his father Ricardo, and Anderson, the Series A preferred director, he could reassert control. As the court put it, Backer leapt into action. So consulting with his own counsel, Backer prepared resolutions for the presentation and a passage at the board meeting that would essentially terminate Grauman as CEO and replace him with Backer, appoint Backer as the CEO director, appoint Patricio Questra to serve as the second common stock director, and amend the bylaws to require a quorum of 3 whenever the board had 6 directors. So essentially, these resolutions would lock in Backer's control of QLS. But at the board meeting, Backer took the position that neither Grauman nor Daddario were directors, and the board was comprised of Backer, his father, and Anderson, the Palisades designee. Backer and his father, therefore, at that point, passed the resolutions over Anderson's objections. So in the litigation, Palisades initiated the litigation in the Court of Chancery to avoid the actions taken at the board meeting. And Palisades' attack on the actions took the form of, as Chris mentioned previously, the now familiar twice-tested framework, which, as Chris explained earlier, under that framework, corporate conduct is tested twice. First, for legal compliance. In other words, did the actor have the legal authority to take the act? And second, for equitable compliance. In other words, in taking the action, did the actor act equitably? Thus, consistent with that framework, Palisades argued, first, that Daddario was elected to the board prior to the board meeting and as a result was improperly excluded from the meeting, and second, even if the board vote was legal, Bacher's conduct in convening the meeting was inequitable. So Palisades argued Daddario was elected to the board in advance of the meeting because the October 28th email from Altos to the company's council constituted a vote of the Series A1 preferred stockholders, or alternatively, that the October email was a written consent of Altos. The court confirmed that the holders of Series A1 preferred stock had the right to fill the vacancy by vote or written consent in lieu of a meeting, but concluded the October email was neither a vote nor a written consent. Stated that an email requesting QLES counsel to take action to facilitate a stockholder consent is not a stockholder vote under a law. The DGCL is clear that stockholders vote at meetings. And a request that somebody else draft a written consent under any sensible reading cannot be construed itself as a written consent. And the way I've read this case and interpret that is, and what the court said essentially was that you need more affirmative language, that there was not an action actually being taken. It was a request for to draft a consent. So there needed to be more affirmative language. So the court did, however, invalidate the actions taken at the board meeting on equitable grounds. And so really the takeaways from this are reaffirming two basic points of law. First, as we talked about the twice-tested framework, it's a restatement of that and reaffirmation of the twice-tested framework. That is, that it's the bedrock doctrine that this court will not sanction inequitable action by corporate fiduciaries simply because the act is legally authorized. And the second is that the actions are voidable if carried out by means of deception, but there must be some affirmative deception before equity will intervene. So the court concluded that Bacher affirmatively misrepresented that he wanted Grauman on the board. And I think without that, it would not necessarily have been enough to form the affirmative deception that the court was looking for. But because he indicated in emails that he assumed Grauman was on the board and requested proposed resolutions placing Grauman on the board, and affirmatively misrepresented that he wanted him on the board, the court found that to be a form of affirmative deception. Also, the court noted that had Anderson known of Bacher's opposition, he could have refused to participate, defeating a quorum and thwarting the coup. As Anderson's presence at the meeting was secured under deliberately false pretenses, any action taken at the meeting was void. Again, an interesting case, just demonstrating the twice-tested framework in that just because something's legal doesn't mean it's equitable, and both analysis should be run through by practitioners when you're contemplating taking certain actions. So the next case we'll talk about briefly is the Salzburg Fee Shabakuchi. I'm sure I'm mispronouncing that. Where at issue was the validity of a charter provision requiring all stockholders to file any claims arising under the Securities Act of 1933 in federal district court. And the motivation for these provisions was the United States Supreme Court's decision in Cyan, the Beaver City Employees Retirement Fund, which allowed state courts to retain concurrent jurisdiction for 33 Act claims. So just by way of background, a stockholder sued 3 companies that adopted a federal form charter provision before their IPOs, Blue Apron, Roku, and Stitch Fix. The stockholders, Yabakuki, sought a declaratory judgment that the provisions were invalid. So the companies argued these provisions were akin to the forum selection provisions that were deemed to be valid in the Boilermakers decision in 2013. That decision paved the way for charter amendments requiring stockholders to bring internal affairs suits, including derivative litigation, fiduciary duty claims, and claims relating to the DGCL in a particular forum. Vice Chancellor Lasser declined to extend, and I should mention in the lower case, or the Chancery Court case of Salzburg Fee, Vice Chancellor Lasser declined to extend the Boilermakers decision to these federal forum provisions because, according to the court, the 33 Act claims do not arise out of the corporate contract and do not implicate the internal affairs of the corporation, but rather arise from the investor's purchase of the shares. The constitutive documents of a Delaware corporation cannot bind a plaintiff to a particular forum when the claim does not involve rights or relationships that were established by or under Delaware's corporate law. So in other words, a federal claim under the 33 Act is a clear example of an external claim, and the Court of Chancery cited several factors to distinguish this. Well, stating while it involves business and affairs of the corporation, it does not follow that these matters involve internal affairs of the corporation. And the plaintiff is a purchaser of securities, and the source of the cause of action is the sale of the security that violates the federal regulatory regime. Defendants need not be directors or officers. They can be anyone that the 33 Act identifies as viable defendant. The event giving rise to the claim takes place just before the plaintiff becomes a stockholder, before the corporate contract applies. And the plaintiffs also don't need to continue as stockholders to assert a 33 Act claim. And the federal claim does not invoke the stockholders' legal or equitable rights under a state law corporate contract. Now, keeping in mind that the plaintiff asserted a facial challenge, which required a showing that the charter provisions cannot operate lawfully or equitably under any circumstances, the Supreme Court reversed, holding that such provisions can survive a facial challenge. The starting point of the Supreme Court's analysis was that Section 102B1 of the Delaware General Corporation Law allows companies to include in their charters any provisions for the management of the business or for the conduct and the affairs of the corporation, or creating, defining, limiting, and regulating the powers of the corporation, the directors, and the stockholders, or any class of stockholders, if such provisions are not contrary to Delaware law. So noting statistics on the number of multi-jurisdictional 33 Act lawsuits filed since the Cayenne case, the court suggested that a federal forum provision could be justified on efficiency grounds and would not violate the policies or laws of Delaware. It rejected a number of statutory construction arguments that the 2015 amendments to the DGCL, which had added Section 115, had narrowed what 102B1 permits. The court disagreed with the Vice Chancellor's limiting construction of internal affairs and the notion that the Delaware's interests went no further than internal affairs properly defined. And the court instead held that there's an outer band of intracorporate affairs as to which an outer band of intracorporate affairs as to which the contractual ordering under 102B1 also is permissible, and that federal forum provisions at least fell within this outer band. And the court, in its case, inserted something of a diagram showing various levels and scopes and finding that there's this outer band of intracorporate affairs. So the court held that such provisions, that is the federal forum selection provision for 33 Act litigation, do not violate any federal law or policy, and also noting that the U.S. Supreme Court had decades ago upheld arbitration provisions precluding state court litigation of 33 Act claims, and that both the federal and Delaware approach to forum selection provisions holds those provisions to be presumptively valid and enforceable. So a couple of takeaways from this case. Again, Salzburg was a facial challenge. The opinion doesn't say that a federal forum provision will be upheld in every situation. And the court did spend some time discussing that, the enforceability of those provisions, but without determining that in this instance. Now, the charter and bylaw provisions, the court said, charter and bylaw provisions that may otherwise be facially valid will not be enforced if adopted or used for an inequitable purpose. The other takeaway is the provisions here were in the certificates of incorporation, and the stockholders had approved them before the companies went public. Now, there's certainly arguments of why these would be valid if placed in bylaws or and had not been approved by stockholders or were added after an initial public offering, but you can't be sure that those arguments would work. And so the language in the opinion stresses contractual setting of these provisions and suggesting that a provision unilaterally created by a board after a public offering may be viewed a little bit differently.
Good morning, everyone. This is Roxanne Houtman. I am going to briefly cover a couple of the more notable amendments to the DGCL that were enacted over the summer. The first provision I'm going to cover is Section 110. This provision authorizes boards of directors to adopt bylaws during emergency conditions and provides for the exercise of certain enumerated emergency powers. In preparing for this webinar, I was thinking back over the last 15 years as to whether or not I had really worked on a matter that had implicated 110, and I could only recall one time that I had even sort of looked at this bylaw, or this provision of the statute. It's an often overlooked provision, but with 2020 being what it has brought about, obviously this provision came into unique focus. The changes this year largely fall into two buckets. First, there were some changes to Section 110A that really relate to how do we define an emergency condition and how do we adopt bylaws. And then the second set of changes that I'll cover is found in a new section, subsection I, which adds 2 additional emergency powers, the necessity for which became apparent earlier this year. So first of all, in Section 110A, the first change really clarifies that epidemics, pandemics, and a declaration of a national emergency are among the types of events that may give rise to the exercise of these emergency powers and the authority of the board to adopt emergency bylaws. This provision previously did not include reference to these types of events. This was a provision that was adopted in 1962. So it includes reference to atomic and nuclear disasters, but now it includes reference to epidemics and pandemics. The second preliminary change that I'll note here in 110A is that there's been a slight modification to the manner in which these types of emergency bylaws may be adopted. We've basically made clear now that they can be adopted by a board, or in the event that a quorum cannot be convened for a meeting, then by a majority of the directors present at that meeting. As I mentioned, the second bucket of changes really relates to some additional emergency powers that have been added in new subsection I. As state and local governments began implementing lockdowns in March and April, corporations determined that it wasn't feasible or advisable, or in some instances legally permissible, to hold in-person annual meetings, which I think, as we all know, springtime is sort of prime stockholder meeting season. And so that was really a problem for companies who had already noticed an in-person meeting. They were really forced to scramble to sort of figure out how to change the meeting to a virtual setting. Other companies were questioning, is there a means to adjourn or postpone the meeting, which was problematic in instances where the company wasn't able to even access the meeting site on the date of the scheduled meeting. So all of this led to a bunch of questions as to whether or not companies were required to send out new notices for either a now virtual meeting or a later meeting. Led to questions about whether or not the record date would be lost or whether you have to bring that forward, all of which has significant cost consequences for the company, which in the middle of a pandemic is the last thing that any company wants to hear. Now, Governor Carney, in his 10th executive order, did relax some of the notice requirements for public companies seeking to switch their in-person meetings to virtual meetings. But the order was fairly narrow in scope and duration. And so that was sort of the first issue that came up in the springtime. The second issue, which is also sort of very common to the spring season, related to dividends that had been declared pre-pandemic. Once the scope of the health crisis really became clear, companies were asking questions about what options did they have with respect to these pre-pandemic declared dividends, who were now in a situation where they wanted to consider what options were available to them in order to conserve cash, pay their rent, to continue to pay their employees, etc. So new subsection I really was intended to address these two separate issues. As amended, as newly added, during an emergency condition, the board or majority of the directors present, if a quorum is not there, may take any action that they determine to be practical and necessary to address the circumstances of emergency with respect to stockholder meetings. This might include postponements, moving the meeting to a virtual setting. It allows companies to preserve their record date, and it also allows public companies to notify stockholders of postponements or changes in the meeting solely by means of a public filing. Another change that was added in subsection I addresses the dividend issue that I referred to earlier. During an emergency condition, the board may change the record date and the payment date of any dividend that has been declared, but whose record date has not yet occurred. The payment date can't, however, be more than 60 days after the record date. And in all events, notice of the change must be given to stockholders as promptly as practical. And again, in the case of public corporations, that notice may be given solely by means of a public filing. One last point I'll make on this section 110, these amendments were made retroactive to January 1st, 2020, which is somewhat unusual for changes to the DGCL. However, I believe this decision was made in recognition of the very unique circumstances presented by 2020. The next amendment that I'll briefly review relates to indemnification in section 145. 145C provides that to the extent that a current or former director or officer is successful on the merits in the defense of a proceeding that falls within 145A and 145B, that director or officer is entitled to be indemnified. It's a mandatory indemnification by statute, irrespective of whether or not that director or officer has rights to indemnification under the company's charter or bylaws, and irrespective as to whether or not that director or officer has met the applicable standard of conduct. Prior to the 2020 amendments, 145C did not define the officers, quote unquote, that would be entitled to this mandatory statutory indemnification. And questions were raised as to whether the term officer includes employees that hold an officer-like title. For example, many companies have hundreds of vice presidents. They're employees with an officer-like title, but they're not, viewed as part of the company's officers as we think about them in terms of sort of the company's C-suite as referenced in the bylaws, but it created confusion because they have an officer-like title. So this year, the changes to 145, the first change, is to provide that with respect to any act or omission that occurs after December 31st, 2020, references in 145C only to officer will mean only those persons who are deemed to have consented to service of process pursuant to 3114 of Title 10. So practically speaking, what this means is that the officers who are going to be entitled to mandatory indemnification pursuant to 145C will be limited to the company's president, CEO, CFO, chief legal officer, controller, and the treasurer or chief accounting officer. It'll also cover any individual that's identified in a company's public filings as being among the highly compensated officers of the company, and any other individual who's consented in writing to be an officer for purposes of 3114B. That litany of officers, if you need to refer back to it, can be found in section 3114B of Title 10. However, and in addition to the changes that were made to 145C, we added a new section 145C2. And what this does is it allows corporations to provide this same type of mandatory indemnification to any other person, even if they're not what we'll refer to as sort of a 3114B officer. So 145C2 specifically provides that a corporation may extend this mandatory right to indemnification to any other person. What this means for all of us now is if you're a Delaware corporation or your client's a Delaware corporation, it might be a good idea to review their organizational documents to ensure the desired indemnification scheme. If a corporation's indemnification bylaws or a provision in the charter broadly provides for mandatory indemnification of directors and officers, and there's no definition or reference to what an officer might mean, and that indemnification is mandatory to the full extent permitted by law, or specifically in instances where a director or officer undefined is successful on the merits, then it's entirely possible that the corporation may be obligated to indemnify non-3114B officers, irrespective of whether or not the standard of conduct has been met. That may or may not be okay with the company. I've seen in many instances people are okay with that, but it's worth a second look. It's worth looking at it to make sure that you're comfortable that your indemnification scheme works for you. The next section I'm going to cover relates to public benefit corporations. Over the last few years, there's been increased investor focus on things like sustainability, social responsibility, ESG, along with significant commentary on the purpose and role of the corporation in society. We've seen this with the now well-known Business Roundtable statement on the purpose of a corporation. We've also seen this in the multitude of companies that have publicly announced their commitment to their respective constituencies and stakeholders, and not just their stockholders. The PBC corporate form, and I apologize, PBC, Public Benefit Corporation, I'm going to refer just to them as PBCs. This corporate form was introduced in Delaware on August 1st, 2013, with the adoption of Subchapter 15 of the DGCL. The statute establishes PBCs as for-profit entities that are intended to produce a public benefit and to operate in a responsible and sustainable manner. Directors of a public benefit corporation are required to balance three things. One, the pecuniary interest of stockholders. Two, the best interest of those materially affected by the PBC's conduct. And three, the specific public benefit that is identified in the company's charter, which is a condition to becoming a PBC. Given the material differences between a traditional corporation or a conventional corporation and PBCs, when the statute was first enacted in 2013, it required corporations electing to opt into or out of the PBC corporate form to obtain the approval of 90% of the outstanding shares of each class of stock, whether or not voting. An incredibly high voting standard that was only applicable in the statute in this instance. No other sort of similar instance where you have such a high voting standard. That voting standard was relaxed in 2015, in part to overcome some concerns that have been raised regarding the corporation's ability to secure such a high vote, and I think more generally a desire to more broadly enable use of the PBC corporate form. In 2020, we further relaxed this voting standard, which I think between 2015 and 2020 had become viewed by some, not all, but by some, as being a potential barrier for corporations that may be desiring to make use of the PBC form, but couldn't get a supermajority vote. So immediately prior to the amendments this year in 2020, 363A of the DGCL provided that the approval of 2/3 of the outstanding stock was required in order for a conventional or traditional corporation to amend its charter to convert into and opt into the PBC form, or to become a PBC by merger. Likewise, 363C prohibited similar types of amendments to opt out of the PBC corporate form, or whether through charter amendment or by merger, without the same 2/3 vote. In addition, 363C required certain amendments to the charter, specifically provisions relating to the periodic statements and third-party certifications that are unique to a PBC. Prior to this year, those amendments required a 2/3 vote. 363A and 363C have been eliminated in whole. As a result, where we stand now is that subject to any greater or additional vote that may be required by the charter, the stockholder approval that's necessary to convert into or out of a PBC, whether through charter amendment or by merger, and any other sort of amendment to the PBC charter will be the default statutory vote that's required under 242 or the applicable merger statutes. In other words, it's a majority of the outstanding staff. In large part, I think that these amendments more closely align PBCs with traditional corporations insofar as it relates to stockholder approvals on charter amendments and the like. The next sort of material or key change that was made in the public benefit corporation statutes relates to appraisal, which I think was viewed by many as another potential barrier to corporations, and in particular private companies that were intending or desiring to make use of the PBC corporate form. Before 2020 amendments, 363B granted appraisal rights to stockholders. Effectively, if you were a stockholder of the corporation immediately before the traditional corporation converted to a PBC through charter amendment or merger, you were entitled to appraisal rights. Not so, not such a surprise as it pertains to the merger conversion, but this is the only instance in the statute where a stockholder was entitled to appraisal rights in connection with the charter amendment. That, however, has been completely eliminated with the 2020 amendments, and more particularly by the elimination of Section 363B. As a result, statutory appraisal rights will no longer be available to stockholders of a conventional corporation that converts to a PBC through a charter amendment. Of course, any merger involving a PBC and a conventional corporation, the appraisal rights will be as otherwise available under Section 262, which is Delaware's appraisal statute. And just note that there have been a couple of cleanup changes to the appraisal statute consistent with the deletion of 363B. And then lastly, there's been a couple other minor amendments to, I don't want to say minor, but there's a couple other amendments to subchapter 15 relating to PBCs. Just quickly, before getting into them, a bit of background on the statutory regime for PBCs. As noted earlier, directors of a PBC are required under 365A to balance the interest of the financial interest of the stockholders, the best interest of those affected by the public company's conduct, and the benefit that's stated in the company's charter. 365B provides that for any decision that implicates that balancing requirement, the director will be deemed to have satisfied his or her fiduciary duties if the decision was informed and disinterested. Before the 2020 amendments, 365C allowed PBCs to include in their charter an express provision that stated that any disinterested failure to satisfy the requirements of 365 will not, for purposes of 102B7, constitute an act or omission not in good faith or a breach of the duty of loyalty. In effect, you had to affirmatively opt in by including a provision to that effect in your charter. So here's what's changed. First, 365C has been amended to make clear that with respect to any decision that implicates this tripartite balancing requirement, the director will not be deemed interested based solely on his or her ownership of stock, except to the extent that it would create a conflict of interest if the company was not a PBC. This effectively limits arguments that a director who happens to be a stockholder gave undue weight to the pecuniary interest of the stockholders in these types of balancing decisions. Second, 365C has been amended to eliminate the need to affirmatively include an express provision in your charter by making what was 365C effectively the statutory default. So in the absence of a conflict of interest, by statute, no failure to satisfy the balancing requirements will constitute an act or omission not in good faith for purposes of 102B7, unless the charter provides otherwise. So we've effectively flipped the default on its head. And then finally, one last point on PBCs. There was a quick amendment to 367. There was a question before 2020 as to whether or not direct or individual suits were falling within the thresholds described in 367. So there's been a clarifying amendment to 367 to clarify that any suit, individual, direct, derivative, or any other type of action to enforce the balancing requirements must be brought by plaintiffs that own at least 2% of the outstanding shares or shares with a value of at least $2 million. All right, one last set of amendments. Look, I focused on sort of what I view to be three of the more critical, more notable types of amendments. There's a handful of other ones. I'll touch on a couple briefly. First, Section 102B7, the Sculptory provision. There was a clarification made that the provision has the effect of eliminating or limiting liability for monetary damages for any act or omission occurring while the provision is in effect. Unless the charter provides otherwise at the time of the act or omission, any future amendment, repeal, or elimination will not revoke the elimination or limitation of liability. Put a different way, most companies had already included language in their 102B7 charter provision that made clear that if the charter is later amended to eliminate the protection available to directors, then the amendment would not apply to any previously occurring acts or omissions. So as a result, this change really just codifies the long-standing common practice. Next couple of sets of amendments. As many of you may know, in 2019, there were some fairly significant amendments relating to the addition of provisions that provided for the use of electronic signatures and electronic delivery of documents. Last year, Section 116 was added to the DGCL that established a non-exclusive safe harbor method to reduce certain acts or transactions to written or electronic documents and to sign and deliver documents electronically. When 116A was adopted, certain corporate transactions could be documented, signed, and delivered through DocuSign or other electronic means. 116B, however, last year expressly excluded incorporator, board, and stockholder consent from the list of documents that fall within 116A's safe harbor. That's been reversed this year. So in 2020, we've amended 116B to eliminate these express carve-outs for incorporator, board, and stockholder consent. And so as a result, companies now may rely on 116A as a basis for using electronic transmissions to document these types of consents. In addition to the amendments to 116B, there's been some conforming changes made to the provisions as shown on the screen, which really go back to the provisions where you can find information relating to the incorporator, board, and stockholder consent. There's also been a minor clarification to 145F. This now clarifies that the prohibition on eliminating or impairing a right to indemnification after the occurrence of an act or omission applies not only in the case of an amendment, but also in the case of a repeal or elimination. This sort of more now closely tracks 102B7. And finally, in the holding company reorganization merger statute 251G, there's been an amendment to eliminate the requirement that the organizational documents of the survivor entity contain provisions that are identical to the certificate of incorporation of the constituent corporation immediately prior to the merger. I think there was a recognition that this requirement was somewhat onerous, and so it's been relaxed a little bit.